We have one of the most prominent lawyers, scholars, litigators in the United States today, Neal Katyal, with us. We're very fortunate to have him and very grateful. Thank you, Neal, for coming. I also want to thank Dean Charlene Gilbert, who will be speaking to you momentarily from the College of Arts and Letters, who's our collaborator on this lecture, and also to the McHale family, especially John, who you'll hear from in a moment, for organizing this. This is a great event. I'm really glad to see the auditorium so full, and I think this is going to be a great lecture today. So again, welcome. Thank you for coming, and I want to turn the mic over to Dean Gilbert.
Good afternoon. Again, my name is Charlene Gilbert. I'm the Dean of the College of Arts and Letters here at the University of Toledo. And on behalf of the College of Arts and Letters, I'd like to extend a warm welcome to all of you, our esteemed guest, and our keynote speaker, Neal Katyal. Today, we're gathered here for the 17th Annual McHale Lecture. This annual lecture is made possible by the generous support of the McHale family, and we are very, very fortunate to have 5 members of the family here with us today. I'd like to thank John, Lila, Frank, who I just saw, there he is in the back, Nago, and David, for your family's generosity and commitment to the intellectual life of this community. This lecture in honor of your parents is an ongoing celebration of your parents' legacy and commitment to peace and justice. I had the good fortune of reading more about your family recently in a book entitled Arab Americans in Toledo, and after reading about your family, and particularly your mother, I was deeply inspired by their commitment to community, to education, and the very essence of a liberal arts education: music, arts, history, philosophy, politics, and more. Your family's clear commitment to equality and the notion that we are all part of one global family is a testament to our highest hopes and aspirations for the students who come through our doors here at the University of Toledo. We, like your parents, want them to understand themselves to be citizens of the world. And today's lecture is one more opportunity to help all of us expand our understanding of our place in the global community. Thank you for making this afternoon's lecture possible. For our faculty, for our staff, for our students, and for the community. We are honored and deeply grateful for the legacy that makes this gathering possible, not only this year, but every year, and for 17 years, the longest running endowed lecture at the University of Toledo. This is a powerful gift that speaks well to the notion that we should all remember and hold close, and that is the remarkable truth that a small group of people can and indeed have made a huge difference in the life of a community, a nation, and even the world. So thank you all for coming. And with that, I'd like to introduce John McHale, professor at Georgetown Law University, the family member who will introduce our keynote speaker.
Thank you so much, Dean Gilbert and Dean Barros. It's very kind of you. I'm delighted to, on behalf of our family and all of the organizers of this event, welcome you to the 17th Annual Maryse and Ramzy McHale Memorial Lecture. Before turning to the introduction, I wanted to actually recognize 2 students who are with us today. In addition to promoting an annual lecture, the fund that my parents started awards scholarships, and we have 2 students here today, Rebecca Stevens and Kennedy Pierce. If you wouldn't mind standing. Thank you. This lecture series was started in 2001 to provide a forum for addressing important public issues of the day, particularly those involving the United States and countries of the Middle East. The lecture series was designed to build bridges and to promote dialogue and better understanding among all Americans about the Arab and Muslim world. And it was inspired by our parents' own lived experiences as immigrants to the United States. Like so many people who come to this country from all around the world, their lives embodied that bridge building. And they added to the rich cultural tapestry of their adopted community and country in countless ways, large and small. From this vantage point, and in light of current events, I can't think of a more fitting person to deliver this year's McHale Lecture than my friend and colleague, Neal Katyal. Neal speaks with a unique authority on our nation's immigration laws and its national security laws, both in terms of the discouraging history of racial and national discrimination and exclusion, and also its more recent post-civil rights era commitment to anti-discrimination norms. Neal is the former acting Solicitor General of the United States, a position he held in 2010 and 2011, after serving for several years as Deputy Solicitor General under then Solicitor General and current Supreme Court Justice Elena Kagan. As acting Solicitor General, Neal was responsible for representing the United States in all matters before the Supreme Court and appellate courts throughout the nation. In that role, he served as counsel of record in hundreds of cases and gave oral argument to the Supreme Court on 15 occasions. And for these and other efforts, Neal was recognized with the Edmund Randolph Award, the highest award given to a civilian by the United States Department of Justice, which Attorney General Eric Holder presented to him in 2012. Chief Justice John Roberts also appointed Neal to the Advisory Committee on the Federal Appellate Rules, where he has served alongside many esteemed lawyers and judges, including former Ohio Solicitor General and current Sixth Circuit Judge Jeffrey Sutton, and former 10th Circuit Judge and current Supreme Court Justice Neil Gorsuch. Since leaving the Justice Department, Neal has built an extraordinary Supreme Court practice at Hogan Lovells, a Washington, D.C. law firm. All told, he has now argued 34 cases before the court, many of which, like his very first case, Hamdan against Rumsfeld, have become true landmarks of American law. Not yet 50 years old, he is currently tied with the great Thurgood Marshall for the most cases argued before the Supreme Court by a minority attorney, a record Neal will soon hold by himself. And perhaps most impressively, from a law professor's point of view, all this while, Neal has continued to write and teach in exceptional fashion as a law professor at Georgetown University, where he is the Paul and Patricia Saunders Professor of National Security Law and the director of ICAP, Georgetown's new Institute for Constitutional Advocacy and Protection. Now, it would be easy for me to spend 10, 15, 20 minutes, maybe the whole period that we have here together, chronicling Neal's many awards and accomplishments, and truly it's a very long and impressive list. There's so much to admire, and indeed so much to envy. Law professors can be an egotistical bunch. But a good way for any law professor, indeed any lawyer, or any American for that matter, to gain a good dose of humility is to reflect on Neal's brilliant career and everything he has accomplished. I want to close these remarks by telling you about one accomplishment in particular, one thing Neal has done that you might not be aware of, that I deeply admire, and that connects with our topic for today. It was an official act he took as acting Solicitor General, and it connects in important ways, I think, with current events and the case that he's been litigating against the Trump administration's travel ban, and I think it's something Neal will be talking about in his remarks. By universal consensus, one of the most regrettable events in American legal history was the forced internment of over 100,000 Japanese Americans during World War II. Famously, the United States Supreme Court upheld the legality of that detention in a series of cases, the most famous of which is Korematsu. What many Americans do not know, however, is that the United States Justice Department played a culpable role in that process by deliberately withholding from the Supreme Court government intelligence that had found that Japanese Americans living on the West Coast did not pose a military threat to the United States, as had been alleged as a justification for the policy. In 2011, in a highly unusual and courageous step, Neal, in his capacity as acting Solicitor General, published a confession of error, acknowledging that the department that he led had acted wrongly at the time in withholding this information from the Supreme Court. In addition to detailing the errors that had been made, Neal lamented the, quote, gross generalizations about Japanese Americans on which his predecessor had relied, such as that they were, quote, disloyal and motivated by racial solidarity. And I think it's in this episode, more even than Neal's marvelous accomplishments and awards, that illustrates what's so impressive about him as a person. It has to do with his character and his integrity and his commitment to what really matters. And it's also why I believe he's uniquely qualified to speak to us today about the Trump administration's travel bans, about other national security issues that come before the United States Supreme Court that he has litigated and that he has studied and done so much to educate all of us about. And so with that, I'm truly delighted and honored to have this opportunity to introduce Neal. Despite his busy schedule, he was willing to come to Toledo, and we're so grateful for that. So please join me in welcoming my friend and colleague, Neal Katyal.
Thank you, John, and thank you to the university for this, for allowing me to be here. It is really an honor to be here speaking with all of you, and an honor to be speaking in memory of your dear parents, Maryse and Ramzy. And I never had the privilege of knowing them, but I do feel like I knew them because I know you, and you are an extraordinary man and scholar and friend. And I've gotten to feel that even more about your parents because I've had the privilege of reading an essay that John has written in honor of his parents. And looking at that essay, and as I was reading it last night, it really is kind of the story of America. You know, Maryse was a community activist and an educator. And the things that you just heard John talking about, creating fora, building bridges, improving understanding, that's what this lecture is all about and what her life's work was about. Ramzy was a brilliant surgeon, chief of surgery at one of the area's hospitals. And, you know, they came here from another country, and yet they spent their time not just like many immigrants, just educating their own children, but educating the community around them. And it's remarkable. I mean, reading what their influences were, they were influenced by Christian thought, Islamic thought, European thought, Arabic sources. The language at the dinner table was not just English, but they were also fluent in French and Arabic. You know, that's what I think of as the best of America. And so hopefully this, which you'll hear in the next little bit, will honor that spirit and that tradition. Now look, I know it's rainy and it's also freezing in here, and I also know that my students at Georgetown tell me I have a soporific effect on them, that I put them to sleep. So I'm going to talk for a while, but I really want this to be some questions and answers too, so I'm not going to spend the entire time talking at you. And the soporific effect was really brought home to me a few years ago. In 2009, when I joined the Justice Department, I was also teaching at the same time. And so I was racing back and forth between justice and my con law class. And at Georgetown, I'm sure the University of Toledo does this too now. You don't put your names on exams, do you? You have like a number or something like that? Yeah, we do that because in the old days, you used to see, you know, J. Smith, you know, writes an exam and you'd see the name on the front and you're like, oh, J. Smith is so nice to me in class and, you know, and is just such a great guy. And so J gets an A. So we eliminated that by putting these blind grading things on our exam. So now it's just a number like 8421 or whatever. And you can, pretty much as a professor discount, anything because of that, because there's not anyone who, kisses up to you all semester isn't going to get anything out of it because it's just a number. But the Georgetown students are clever. So, for years I'd have stuff on the bottom of exam 8421 or whatever it'll say, Professor, you have the most beautiful children, or, what a beautiful tie you're wearing, or, things like that. But you can discount all that. But that year in 2009, I had an exam, exam number 42-94 or whatever, and at the bottom of the exam it says, Professor, should I have 1 hour left to live? I should like to live it in your class. I'm thinking, do we have A pluses at Georgetown? It's a good one. And then there's a footnote. You law students, you love your footnotes. And the footnote says, turn the page over. That is because, Professor, you make 1 hour seem like an eternity. So, I will give you some room for questions. I want to talk about the role of the courts in times of national security threats. That used to be a pretty simple thing. And I'm going to tell you 3 stories. And basically, that'll be the lecture, 3 stories. But it used to be pretty simple. That is to say that, the way I grew up learning constitutional law as a student was basically, president says something, they generally get what they want. The courts are not going to interfere. Courts are generalist institutions. They don't have intelligence briefings. They don't, understand the world of security. They aren't elected for that. They are generalist Article III judges. And so when a president says, I need something in a time of a national security threat, that president gets it. There's only, up until, very recently, the 9/11 cases, there's only been one example in United States history in which during a time of armed conflict, a president said, I need something, and the Supreme Court said, no, you can't get it, it's unconstitutional. That was the Steele seizure case in 1952. But otherwise, as I used to tell my students, if you're the president in a time of national security threat, you really have to try to lose your case in the Supreme Court. It's kind of like failing a class at Yale. You got to really try to get it done. That is, they're so deferential to you. But things changed a little bit after 9/11, and I suspect will change even more in the years to come. So what happened after 9/11? So, I remember, the nation horribly attacked in September, and on November 13th, 2001, I was teaching in New Haven at the time, and I was living in a friend's house, and I was teaching constitutional law, and all my students, like that week, I was actually teaching war powers. They were all like, oh, you're so deferential to the president. You think nothing the president does is unconstitutional, and so on. And, I'd been National Security Advisor of the Justice Department. I kind of thought, yeah, it's kind of true in general. I think the president has a wide berth in this area, and so on. But on November 13th, I see on the bottom of the CNN news screen, all the news channels had moved to that crawling thing at the bottom, the news crawl, so that you could see the news while they were all talking. And it says at the bottom of the screen, President issues military trial order for suspected terrorists at Guantanamo Bay. And I thought to myself, that's really interesting, because when we had the embassy bombings in '98 that bin Laden had done, we looked into that, but we concluded it was obviously unconstitutional to have military trials without Congress's authorization. So I said, I wonder how they're doing that. So I got on my friend's computer. This is like dial-up internet at the time, and I don't know that Google existed, or I don't know how to use it or whatever. So I type in whitehouse.gov onto the search bar, and I read the president's order. And my first reaction, honestly, was I thought it was on a spoof website, like one of those fake Onion sites or something like that, because it didn't seem to me possible that the president could be asserting all of these powers. What he was saying is, I'm the president, George W. Bush. I am setting up this trial system at Guantanamo from scratch. I'm going to handpick the prosecutors, handpick the defense attorneys, handpick the defendants, define all of the rights that they will have at trial, which he actually said 0 constitutional rights, define the punishments, which he said would always include the death penalty, define what the offenses are, the elements of the offenses, conspiracies and the like, handpick the judges, handpick the appeals judges, and the very last lines of the president's order said, the federal courts have no business reviewing what I'm doing at Guantanamo Bay, no right of habeas corpus. So I printed that out and I walked into my constitutional law class and said, here's something that is obviously unconstitutional. And in that class, I was just a law professor at the time. I'd never litigated a major case or anything. But in that room was a staffer for Senator Leahy. And she told the senator about it, and he invited me to testify. And, and I testified and said this is unconstitutional. And 2 weeks later, Larry Tribe, very famous professor at Harvard, testified and said similar things. It's unconstitutional. And so we got together, Larry and I, and did what law professors do, which is we wrote a law review article saying it's unconstitutional. No one read it. Surprise, surprise. And the Bush administration went ahead with launching these military trials. And so I then got in touch with the JAG attorneys, the military defense attorneys assigned to the Guantanamo representation, and I said to them that, we should bring a test case and challenge this, because again, very hard to challenge in times of war what a president does, but when you're acting so against the grain of American tradition and American constitutional law, I thought it was possible. You still want to create a good test case whenever you're bringing a major constitutional case. So, I'd said to them, you don't want someone as your plaintiff who has blood on their hands, for example. Now, the folks that were being indicted were people at Guantanamo, so it wasn't like picking among the fine people in this room as your test plaintiff. It was people who'd all been accused of doing something or alleged to do something bad. But within that, the military defense attorney, Charlie Swift, Lieutenant Commander Swift, calls me and says, okay, I think I've got the guy. Do you want the good news or the bad news? I said, well, what's the good news? He says, well, the plaintiff does not have blood on his hands. And that's what you wanted, and I found him. He doesn't have blood on his hands. He just drove a bad guy around. I said, okay, so what's the bad news? He says, well, that's the bad news. He drove bin Laden around. And I thought to myself, that might be hard, but not impossible. We often don't prosecute drivers. We didn't prosecute Hitler's driver and so on. So, it did seem to me possible to do. And again, within the range of people, he seemed like the best one. So we decided we'd take him. Now, in this weird system, the prosecutor had to appoint the defense attorney. That's the way President Bush had set it up. So we kind of had to bait the prosecutor into the defense attorney, into us being appointed as the defense attorney. And so we basically said, well, we could try and negotiate a plea because they really wanted to legitimize their, fake court system, and with some pleas they could do that. And so Swift was appointed for the limited purpose of negotiating a plea. The prosecution wouldn't say what the offense was that he would be pleading to, or what the possible sentence would be. So Swift knew that he couldn't negotiate in good conscience, a plea agreement to an unspecified charge when the death penalty is on the line. So he knew he was going to have basically one chance to go down to Gitmo and meet Hamdan. And so he calls me, and they basically gave him 15 minutes to get on a plane or so. And he calls me and says, I've got this, but I'm getting down the plane now. And I said, let me send you a piece of paper. So I sent him a piece of paper that says, I, Salim Hamdan, the driver, agreed to have Charlie Swift and Neal Katyal file a habeas corpus action on my behalf. And we had to get it signed right then because we knew we'd be cut off from Gitmo after that and then be accused of not being able to represent him, not acting in his interest, and so on. So we get that piece of paper signed, and that's the way the case begins. And we challenge this as basically just a fundamental betrayal of what American principles are, which is the idea that you have a civilian court trial, or if you're in the military, you get a court-martial system, or indeed if you're a terrorist, you can have a court-martial system. The Congress has authorized that in the early 1900s. But what you can't do is make up your own system but on the stroke of one man's pen, the president. This was going to be a tough challenge. We knew it. But, we won it in the trial court, lost it in the Court of Appeals in the D.C. Circuit. lost it. There were 6 different issues in the case. We lost each one 3 different ways, so there were 18 holdings against us. But nonetheless, argued in the Supreme Court. It was my first Supreme Court case, Hamdan versus Rumsfeld. I was arguing against the Solicitor General, Paul Clement. It was his 35th. But ultimately, we won. And I remember sitting in the courtroom that day on June 29th, 2006, and Justice Stevens announces, he says, "I have the opinion of the court," and he announces it, and it's he reads for about a half hour. It's 174 pages, the opinion, but it's very clear what he's saying, which is this is unconstitutional. President can't do it. Congress has to authorize it. This violates the Geneva Conventions, what the president had been doing. And by the way, that wasn't just a Guantanamo holding, that was for the whole world. So waterboarding ends, because of Justice Stevens' opinion, ghost prisons end, a whole bunch of stuff changes right away. And so we're listening to that. And then we listen to the dissents, because in the Supreme Court, if a justice disagrees really strongly, they'll read their dissent out loud. They'll summarize it. And Justice Scalia begins by saying, "Americans will die because of this decision." And then Justice Thomas says, "I've never read a dissent in my 10 years on the bench, but I feel so strongly, I'm going to read one here." He actually had read a dissent, he'd forgotten. But in any event, it's a very solemn occasion, and the opinion's going down, the reading is going on for about an hour. And then we go out to the courtroom steps, and it is like a media madhouse. There are 500 cameras. The president had already given a press conference about it while we were inside the court, saying he's going to study it, and he disagrees with the decision, and blah, blah. And everyone is asking, what does the decision mean? Now, it's 174 pages. I hadn't read the decision. But I'd listened to a little of it, but I knew basically what it meant. And so this concludes the first of the 3 stories. What I said was almost verbatim this. I said, here's what happened today. In America, you had the lowest of the low, a guy accused of being the worst guy, the driver to the most suspected, the worst terrorist in our history, most evil men in the world, bin Laden. And he brings this case against not just anyone, but the highest official in the land, the President of the United States, the most powerful man in the world. And he brings this case not in some traffic court, but in the Supreme Court of the United States, the highest court in the land, and he wins. That's something remarkable about our country. In many other countries, I didn't say this, but in many other countries, Mr. Hamdan would have been shot for bringing his case. And more to the point for me, his lawyer would have been shot. But that's, and this now is what I'm saying on the courtroom steps, this is what makes America special, that we think our founders gave us a system of checks and balances, understood our leaders are going to make mistakes. I reminded the media about what then Judge John Roberts said at his confirmation hearings to be Chief Justice. He said, the great thing about the Supreme Court is on the one side of the courtroom, you can have the fancy corporation with all their law books piled up high and all their law firm lawyers and all that. And on the other side, you can have the little guy who's got none of that, no fancy lawyers, no law books. But if the little guy's got a good argument, he can win. Not always, but he can. And that, to me, is what happened on that day, vindicating America's promise, our judiciary's promise. Now, that wasn't always, and this is how I started, the way that our court systems work, particularly when you deal with national security or immigration. And John had mentioned Korematsu and in the Hirabayashi cases, the Japanese internment cases. And before talking about them as the second of the 3 stories, I do want to just tell you a little bit about how I got interested in that. So when I was running the Solicitor General's office, the Supreme Court, like school children, has summers off. And so the Solicitor General, because you're pegged to the Supreme Court, I'm not saying they're school children, I'm saying that they follow the same calendar. You have summers that are basically downtime in the Solicitor General's office as well, because the Supreme Court's not sitting. And so as a result, I always came up with a project. And the project I came up with for one summer had to do with some reading I'd done in college about the way in which the federal government had treated immigration. And I just had stuck in my mind, and I remember there was some story about the Japanese internment, but I wasn't too sure. This was all triggered because in May, I was going back and reading some of our immigration briefs that the Solicitor General had filed, and I found a brief filed defending the Chinese Exclusion Acts. This is in the Fong Yu-ting case in 1892. And these were about laws that really dramatically, barred Chinese from coming in because they were untrustworthy. And the Solicitor General had to defend this, or chose to defend it. And the Solicitor General, Aldrich, files a brief in the Supreme Court saying that the president has plenary power over immigration, and indeed that principles of international law justify exclusion on the basis of nationality. And the brief goes through King Alfred the Great, who defended Anglo-Saxon kingdoms against the Vikings in the 9th century, and how the English had expelled the Danes and the Scots, and, quote, outlandish people calling themselves Egyptians. All of this is in the brief. And indeed, the brief goes on to say, there's contemporary evidence of this power used by, quote, the civilized nations of the earth. Quote, Russia is now engaged in expelling the Jews, and laws looking to a limitation on their rights and regulating their status have been in recent years a source of party strife in the German Empire. That's in 1892, obviously, 50 years or so before World War II. But he then says, the Solicitor General says, that the Chinese are, quote, a class of people not suited to our institutions, remaining a separate and distinct race, incapable of assimilation, having habits of the most pernicious character, working at wages that debase our own laboring class, and by Congress declared to be a people of such a character, and so inimical to our interests, as to require their coming here shall be prohibited, and means taken to identify those already here. That's what the government's top lawyer to the Supreme Court said about an entire nation of people. And so I started thinking about it and started pulling the historical archives on what happened in the World War II cases. And it is a remarkable story. And the Solicitor General at the time is a guy named Charles Fahey, has a distinguished career, serves for 30 years on the D.C. Circuit after he is Solicitor General. And I don't mean to judge him in general. I'm sure he did lots of other things, but with respect to the Japanese internment, he acted grievously wrongly. So the way this starts, you all know, December 7th, 1941, you have the attacks. And then in February of 1942, FDR declares the Pacific Coast a zone from which, quote, any or all persons may be excluded. And General John DeWitt of the Army then takes that to mean, oh, well, FDR is saying I can exclude people from the Pacific Coast. I'm going to exclude Japanese Americans because they are untrustworthy. And so he imposes all sorts of restrictions on them. It starts with curfews. It later then goes to movement restrictions, and then later the forced internment of 120,000 Japanese Americans. Now, there were a few brave individuals that decided to challenge this scheme. I think many of you have heard of Fred Korematsu, but maybe fewer have heard of Gordon Hirabayashi, and Gordon is really one of my heroes. So this is a guy, he's 18 years old, he's a student at the University of Washington, and he sees what's going on with these orders against Japanese Americans, and he decides to challenge it. Now, he's born in America, he's never been to Japan, his parents are from Japan, but he's never been there. So he goes and he stays out late and past the curfew, and he violates the movement orders, goes to maybe the coastline or something like that. And then he goes to the FBI and says, hi, my name is Gordon Hirabayashi. Please arrest me because I've violated these orders, because I think they're unjust, and I have a duty to disobey unjust laws. The FBI says, look, you got no record. We don't really, arrest first-time offenders for this. Just, comply with the curfew next time, please. Gordon says, no, I have a duty. His religion was a version of Quakerism, and I have a duty to resist this law. Arrest me. So they say, okay, fine, we'll arrest you. They put him on trial. Gordon defends himself, saying, yes, I did it. I violated all this stuff, but it's unconstitutional and immoral, all these laws. And the judge says, that's a nice defense, but I'm not buying it. I'm convicting you. Come back in next week for sentencing. So Gordon comes back the next week for sentencing. And reminiscent of what Charlie Swift told me that I said a minute ago about good news and bad news, that's what the judge says. He says, look, I got some good news and bad news for you. The bad news is you've been convicted, and so you have a sentence to serve. And the sentence is 60 days in a prison camp. So Gordon says, what's the good news? The judge says, the good news is the only prison camp is 1,000 miles away in Tucson, Arizona. This trial is taking place in Seattle. And so I don't have the resources in the midst of fighting a war to send you to serve your sentence 1,000 miles away. So, Mr. Hirabayashi, you don't have to serve your sentence. Gordon says, no, I got to serve my sentence. It's part of my duty as a Quaker. I've got to resist and I've got to serve it, and I have to obey the fact that this court has sentenced me. The judge says, look, I can't get you there. I don't have the resources. So Gordon says, don't worry, I'll get there myself. Gordon hitchhikes the 1,000 miles to serve his sentence. And he shows up. This prison camp is 30 miles outside of Tucson. And he shows up one night and he says, I'm Gordon, I'm Hirabayashi, I'm reporting to serve my sentence. And the warden's like, I got no papers about you. Don't worry, you don't have to serve your sentence. And Gordon then goes through the whole thing again. No, I got to serve my sentence. I'm a Quaker, blah, 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 blah. And the warden says, come back tomorrow. So he comes back, and then the warden figures out who he is, and he starts serving his sentence. But that's the kind of man he was, not someone who just blew off his obligations because he didn't think they were moral or whatever. He worked within the system. He challenged it. And so he fights his challenge, brings his case to the United States Supreme Court. And then, like now in the Solicitor General's office, when a case comes to the U.S. Supreme Court, it's assigned first to a line attorney. And the line attorney who's assigned to it is a guy named Edward Ennis, who's working in something called the Alien Control Unit. He had been part of the Solicitor General's staff and then gets moved over there. And his job is defend what's happened to Hirabayashi and what's happening to the Japanese Americans. And he starts looking into it, and he says, I can't really defend it. It just looks unconstitutional. And he realizes that the Office of Naval Intelligence, which has the lead on the whole Japanese-American threat, has written a report written by a guy named Kenneth Ringel. And that report totally contradicts everything the government is saying to the courts about the need for the Japanese-American internment. It says that only a tiny percentage of Japanese Americans are potentially disloyal, that those that were known to the government and could be dealt with on an individual basis, that there was no need for a mass internment. Quote, this is a quote from the Ringel report, the entire Japanese problem has been magnified out of its true proportions, largely because of the physical characteristics of the people. And J. Edgar Hoover, no civil libertarian, the FBI director, agrees with Ringel, agrees that this was not something that we should be doing. So, and this is all in documents to the Solicitor General, Ennis writes a memo to Fahey, the Solicitor General, saying the Justice Department, quote, has to consider most carefully what our obligation of the court is. I think we should consider very carefully whether we do not have a duty to advise the court of the existence of the Ringel memo and of the fact that this represents the view of the Office of Naval Intelligence. It occurs to me that any other course of conduct might approximate the suppression of evidence. Suppression of evidence. That's all in the memo. What does Fahey do? Nothing. He orders his deputy, Arnold Rahm, to take over the drafting of the brief, and he doubles down on all the racist stuff. He adds 15 pages of stuff in the brief saying that Japanese Americans can't be trusted, and their big evidence was that they were creating schools to teach the Japanese language to their kids. But these schools were really fronts for Japanese nationalist indoctrination, the brief goes on to argue, and so on. And so it's not surprising in one sense that in June of 1943, the Supreme Court unanimously upholds what happens to Hirabayashi, saying, quote, the military had reasonable ground for believing the threat was real. Because they weren't told anything else. The government held all those intelligence cards, and they didn't show them to the Supreme Court. So all they knew about was what the Army was saying, which is we need this, we need this, we need this for national security. Japanese Americans can't be trusted, Japanese schools, and all the rest. And then you had the Korematsu case the next year, which is obviously more famous. And you had another horrible set of events happen. So in this one, another challenge to the Japanese American treatment. The brief is assigned to, not to Ed Ennis, but to a guy named John Burling, the line attorney. Now, Burling comes from a legendary family of lawyers. You might have heard of Covington and Burling. That Burling is John's father, okay, who founded the firm. And Burling looks into the Japanese, stuff and the intelligence and so on, and also concludes that it's totally, bunk. And the Army has a new argument by the time of Korematsu. The new argument is that Japanese Americans are taking surveys of our critical infrastructure, our troop movements and so on the Pacific coast and all of our facilities, oil, gas, and they are using radios and mirrors to signal it to Japanese subs that are off the shore Pacific coast, and sending all this intelligence information to them, that there are all these spies in our midst. There's only one problem with this. The FBI looked into it, couldn't find any evidence of this, and the FCC looked into it and couldn't find any evidence of this. So there are all these reports that say this is just made up. So Burling writes a draft of the brief, and the draft of the brief condemns what the Army's defense of this and what the Army calls the final report to justify how they're treating Japanese Americans. So he does what any government lawyer would do, which is to say, we're not relying on this final report, that you can't rely on it. Then, like now, whenever a brief is written, the draft goes around to all the affected agencies. Here it was called the War Department, now the Pentagon. And they hit the roof saying, how can you undermine our generals in a time of war and so on? You're being unpatriotic. This is going to undermine the war effort. And so the Solicitor General, Fahey, says, okay, no, we're going to defend the final report. We're going to defend the Army's treatment and so on. Burling then gets with Ennis, and they together say, there's something really wrong going on here. We can't deceive the Supreme Court and rely on something. Fahey says, I'm the Solicitor General, and I'm going to do what I'm going to do. So they did something really unusual, Burling and Ennis. They actually went down in the Justice Department. These are what the documents reveal. And they went down to the number 7 guy, the head of the criminal division, far outranked by the Solicitor General. But the head of the criminal division was a guy named Herbert Wexler, a very legendary guy. If you take in criminal law, he wrote the Model Penal Code. And they explained this to Wexler, and Wexler says, we all can't put our names on this brief if they don't repudiate the final report and say that this is wrong. And so Wexler drafts a footnote and says, if you don't sign, Fahey, this brief with this footnote, then we will not sign the brief, and the brief will not go to the Supreme Court, effectively. So the footnote says as following, quote, the final report of General DeWitt has relied on this brief for statistics and other details concerning the actual evacuation and the events that took place there, too. We have specifically recited in this brief the facts relating to the justification for the evacuation, of which we ask the court to take judicial notice, and we rely upon the final report only to the extent it relates to such facts. Now, who knows what that means? I've read this now over 600 times. I still don't know what it means. And that happens in the government all the time. When I was running the Solicitor General's office, you'd have agencies come in with different views, typically be state versus defense or EPA versus commerce. These, I think, distinctions don't matter today, but they did, and let me assure you, they matter in most administrations. The people have different views. You have a meeting about it, and often someone suggests, well, let's paper over the difference. Let's write a compromise brief that kind of genuflects to both sides and kicks the can down the road. And that works well in other settings, like if you're, if it's not a court case, but if it's just a policy or something like that. It doesn't work so well in a court case because you have this pesky thing called an oral argument. And when you write a footnote like that in a brief, you're going to get asked about it because the justices are darn smart and they know exactly what you're doing. And that's exactly what happens at the oral argument in Korematsu. Justice Jackson, who had previously served as Solicitor General, sees this footnote and he says, what are you saying in this footnote? Are you saying that you don't agree with the Army in the final report? And here's what Fahey says, and this is the end of story 2. Quote, there is nothing in the brief of the government which is any different in this respect from the position it has always maintained since the Hirabayashi case, that not only the military judgment of the general, but the judgment of the entire government of the United States has been in justification of the measures taken, and no person in any responsible position has ever taken a contrary position, and the government does not do so now. Nothing in its brief can be validly used to the contrary. End quote. He says that after Ennis, after Berling, after the FCC, after the FBI, after Ringel, no one's ever taken a contrary view. And so, is it surprising that the Supreme Court, 6-3, sides with the government and says that relying on the Hirabayashi rationale, that the military has reasonable grounds for believing the threat is real? So that's the kind of traditional way in which the courts deal with this. They deal with this by trusting what the executive says when they say national security crisis. And then that brings me to today in the third story. So, I think all of us saw after the first weekend, during the first weekend after inauguration, what was going on in the airports because of a Friday night order, mass chaos unfolding. And 4 of my associates approached me and said, you know, we should do something about this. And I represent Hawaii, the state of Hawaii, on a lot of their Supreme Court stuff. And so I called the AG, Doug Chin, who's a remarkable attorney general, and I said, you know, maybe we should think about challenging this. Unfortunately, others were thinking about it too, from the ACLU to other attorneys general like Ferguson and the state of Washington and so on. And so the first set of challenges unfold. Ours was behind in the queue compared to others, and so those went forward, and so the first ban was struck down pretty quickly, even though the president was taunting, "See you in court" and stuff like that. Once he lost, he didn't want to see anyone in court. So he then changed the executive order, and he says, "I'm going to make a different one, new and improved one," and but his advisors were dispatched to TV to say this is exactly the same as the first executive order. And the genesis of this was the president in December of 2015, on December 7th actually, perhaps no coincidence, said, quote, Donald J. Trump is calling for a complete and total shutdown of Muslim immigration to the United States. He likes to speak of himself in the third person. And then he said, quote, I think Islam hates us, and other things like that. And that's what these bans were about. In fact, when he signs the first executive order, he reads the title of it, which has like a kind of neutral sounding title, but he looks up at the cameras and says, we all know what that means. And indeed we did, and so did the courts. And so the courts then struck down the second one. And there are 2 different kinds of lines of attack that have been going on and challenging the second one. One is that this violates the Establishment Clause of the Constitution. The idea that we all came, our founders came to this country in order to flee religious persecution. And indeed, some of the colonists tried to enact laws that restricted immigration on the basis of religion to keep their state religiously pure. And the First Amendment was designed to say, no way, that's part of the English tradition that we fled from. And we can't have a world in which we, make immigration decisions on the basis of who someone prays to. So that's one set of challenges. That was accepted en banc by the Fourth Circuit in the IRAP case. And then yesterday, the Supreme Court vacated that in light of Travel Ban 3. I'll talk about that in a moment. But that is the Fourth Circuit en banc holding. There's a separate set of challenges that have to do with the way in which, does this comply with the way in which immigration law unfolds? And, some of you, may remember the immigration systems, that used to be set up before 1965 when you had country quotas, certain number from here, certain number from there, and so on. 65 got rid of all of that, massive sweeping changes to the immigration laws. And one of the things it did was to say, we're not going to think about people on the basis of their nationality. We're going to think of them on a much more individualized basis. And indeed, this is part of the statute. This is section 1152. Quote, no person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's nationality. So big, huge change. Indeed, Judge Friendly, perhaps the most legendary Court of Appeals judge to have ever served, or maybe with learned hand, says the next year after this is after the statute's enacted, sweeping different landmark change, it bars any nationality-based discrimination. And now here you have President Trump saying, oh no, I'm going to cherry pick certain countries and say, nope, you can't come at all if you're from these countries unless you go through this waiver process that he hasn't even defined. And then he had some other choice provisions of his executive order banning all refugees across the globe for a 120-day period, obviously at a time when a majority of our refugees happen to be Muslim. So those statutory challenges say, look, even if you think the president has the constitutional power to discriminate on the basis of religion, he doesn't have the power to discriminate on the basis of nationality, and doesn't have the power to kind of do so without at least making really strong findings that there's an urgent national security threat. And, you know, the findings that were there, you know, in Executive Order 1 was challenged, and the Court of Appeals for the Ninth Circuit said, you know, there isn't any evidence that you need this. And so they went back, the lawyers for the Trump administration, they took 2 months, and they came back with evidence for why they needed to have these travel bans. And the evidence was 3 things. Number 1 was 2 people from Iraq who had come to the United States and engaged in acts of terror. So that's one of their defenses of Executive Order number 2. And the other defense was a refugee from Somalia had come and engaged in acts of terror. That was their whopping evidence. Now, the problem for this was twofold. Number 1, between Executive Order 1 and Executive Order 2, 1 country dropped out. Executive Order 1 covered 7 countries. Executive Order number 2 covered 6. Which was the country not covered? Iraq, the same country that the 2 people were from. The other thing that changed was they said, if you're a child, then you get a waiver. You're allowed to come in if you're a child. You're not a terrorist threat. That Somali person who I told you, the refugee who came in and committed acts of terror, he had come in at the age of 2 and committed an act of terror at the age, when he was 21. So that person would have come in anyway under their executive order. So that was the whopping evidence. And that's why, not surprisingly, the Ninth Circuit struck down Executive Order number 2. We then thought we were going to the Supreme Court, and we're preparing for that. And, you know, the president was all talking about how, again, see in court and this and that. But, you know, last week they flinched and decided to announce Executive Order number 3. Executive Order number 3 looks pretty much like Executive Order number 2, except it does 2 things. It makes it permanent instead of a 90-day travel ban, which just seems worse. And it adds 2 countries, North Korea and Venezuela, to the list, because we all know that the North Korean, you know, immigration threat is real and omnipresent, and you know, you should watch out for that North Korean over there. Very transparent what's really going on. And, you know, as the president says, you know, we all do know what that means. And so, you know, we will be challenging that. We filed our challenge, you know, yesterday to the 3rd version, and we'll be bringing that up through the courts as well. And we expect the Supreme Court to rule on this unless the Trump administration flinches again, and we have, you know, number 4. But however many versions of this there are, if it's the same policy, we'll challenge it on the same grounds. And we expect that the courts will do the right thing on the exact same grounds that they've said before. I know I've been talking for a long time, so let me just say maybe a couple minutes of final remarks about this, because this may just illustrate the importance of it. You know, I argued this case in the Court of Appeals in the Ninth Circuit on May 15th. This is a very unusual argument. It was actually on live TV across the globe. And that changes, by the way, how you think about oral argument prep, because any mistake you make can become an internet meme right away. And so you're really thinking hard about that kind of stuff, and, like, you know, how someone can twist something and so on. But you know, it was also unfortunate because I'm a big believer in television, but in televised arguments. But it did mean that there were some security threats and so on, and there were guards at my house, and I have kids and so on, and that's something that kids don't totally understand. And my 12-year-old said, Dad, why are you doing this? What is this case about? And I told him about the First Amendment, and I even told him about Section 1152. He's 12. That didn't work too well. But so that was on May 16th. I'd come back from Seattle, and then something the next day happened, which really crystallized why we're doing this case. So Ann Coulter writes a column. It's syndicated in 200 newspapers. They all made the individual decision to publish this article. And the article is called, "Every Time I Try to Be Mad at Trump, the Media Pull Me Back." And it begins with this choice nugget. Hey, you know what might make more sense than banning laptops? How about banning Muslims? Bear with me here. I'm still working out the details, but I'm almost certain a federal judge in Hawaii can't block a president's temporary ban on Muslim immigration. To preserve their judicial coup, this Monday, the Ninth Circuit sent out the geriatric ward to hear an appeal of the Hawaii judge's absurd ruling. At their ages, there's a good chance the judges will be dead by the time the Supreme Court overturns them. Now, not content with insulting the judges, she then says this, quote, "Arguing against Trump's exercise of his constitutional and statutory powers was first-generation American Neal Katyal. There are plenty of 10th-generation America haters. You couldn't get one of them to argue that we should end our country through mass immigration." So all this is in the article, and that's when it all clicked for me. I mean, why am I doing this case? Why are we doing this case? Because of really that statement, the idea that being a first-generation American would disqualify me when the country had given me so much, the idea that mass immigration would, quote, end our country as opposed to, as this lecture series demonstrates, being what the country is all about. I thought about so many things in my past. I thought about my parents coming here, my dad from another country, my dad arriving with $8 and buying a used car for 50 cents that he slept in every night while he fixed it up to make enough money to eventually rent an apartment. I thought about my dad's first job offer, which was at a slaughterhouse, not an ideal job for a Hindu. I thought about my mom when she went with my dad to get a mortgage, and she applies at the bank, and she was pregnant. She was 8 months into having me, and the bank officer looked at her and said, "You're not going to be able to earn money because you're pregnant." And my mom's answer was, "Oh no, I'm just fat." I thought about all the hate mail I received about being a Muhammad lover, both after Guantanamo and after this case, because the haters aren't very good at keeping Hindus and Muslims straight. But then I thought about the glorious Constitution. I thought about our First Amendment. Our First Amendment, Congress shall make no law respecting the establishment of religion. I thought about our national motto, E pluribus unum, out of many one. And that's the answer I'd like to have given my son. It's the answer I give to all of you. And that is the answer, just to bring this all back full circle, to the final words that a son wrote about his dad. This is what John wrote in the essay. This is the very end of the essay that John wrote about his dad. It's a quote from Bertrand Russell, and the quote is this: "Those whose lives are fruitful to themselves, to their friends, or to the world are inspired by hope and sustained by joy. They see in imagination the things that might be and the way in which they are to be brought into existence. In politics, they aim at making the world as a whole happier, less cruel, less full of conflict between rival greeds, and more full of human beings whose growth has not been dwarfed and stunted by oppression. This is the way of life recommended in the Gospels and by all the great teachers of the world. Those who have found it are freed from the tyranny of fear, since what they value most in their lives is not at the mercy of outside power." Thank you.
time for questions. Neal does need to leave right at 3 o'clock to get on a plane, but we actually have about 25 minutes, and he's graciously offered to take questions. So I'm happy to call on folks. Do we have a microphone? Great. So, thank you.
You can probably hear me. Thank you. I feel much after this.
He can't hear you, maybe others can.
Are you worried about Trump's appointment of judges? Do you see that as, do you feel fearful about the future with the judges that might be making the decisions that, thankfully, judges have made good decisions up till now? So.
I feel more fearful of the decisions than the judges, quite honestly. That is to say, so far the judicial appointments, there have been some pretty horrendous ones, but so far many of them I think have been in the mainstream and good. Different people can have different views on that. My test is, I had worked for Elena Kagan before she was on the Supreme Court, and I was very mad at the Republicans who voted against her. I thought she was very qualified. And my view is if there's the conservative equivalent of an Elena Kagan, either for the Supreme Court or the lower courts, we as Democrats, should support that person. In general, that's what many of the appointees have been. So, I will, cede to no one in my condemnation of some of the judgment errors that President Trump has made. But on the judges thing, so far it hasn't been the nightmare scenario that at least I feared that it would be. Up on top, any questions?
Hi. I was just wondering if you believe that there's going to be any possibilities of executive power being controlled by the judicial branch in the future, like especially through the Trump era and afterwards, because it seems like the legislative branch doesn't want to take that upon themselves.
Yeah, no, it's a really good point. I mean, I think one of the hard things for the courts right now is, our founders designed 3 branches of government, of which the judiciary is supposed to be, as Hamilton says in Federalist 78, the least dangerous branch. And it's normally up to Congress to do a lot of things, but Congress seems incapable of doing just about anything except maybe agreeing on when National Groundhog Day is or something like that. And so it forces the courts into a role that they don't totally want to be in. You're absolutely right. And I think it's hard. They're struggling with it. They were struggling with it in the healthcare cases, particularly the statutory case, Sebelius. And they're struggling with it now, I think, in these agency cases because, President Trump's view is, okay, if Congress isn't going to act, then I am. I'm going to act on environmental stuff and labor and this and that. And so the cases get teed up to the court as just agency versus individual plaintiffs, and Congress is nowhere to be found. And that's I think, a pretty sad thing. That's why I'm a big fan, for example, of sunset statutes, so that, Congress passes a law, but it expires in 4 years or 6 years or whatever without affirmatively re-upping it. And that forces Congress to act. And so if we saw more things expire, I think we'd see a little more pressure on Congress to do something. But right now, I think it's a real problem, and it forces the courts into an uncomfortable situation. Absolutely. There's a question over there.
Thank you for joining us and for your lecture today. I've heard the Solicitor General described as the best lawyer job in the United States. And you mentioned the summers off, but professors get that. Could you talk about what it was like to serve in that role and what some of the neat and less neat things were?
I mean, it's a great job. I actually think being a law professor is a better job. It is a great job, and it's a real privilege to do it. But it's also a privilege to teach. And and a deeply inspiring one for me. So I wouldn't compare them. I will say one of the great things about the Solicitor General job is, in general, it's above politics. You know, when I came into the office, I looked at what the Bush administration had done. I didn't change a single thing. And that was, you know, enormously controversial, and I think the president didn't totally appreciate that, but that's the role of the Solicitor General, which is to speak to the Supreme Court on behalf of the United States government, and those positions generally do not change from one administration to the next. I'm a little surprised that the Trump administration has changed its position on so many things so fast before the Supreme Court. Certainly the Obama folks who were running that office didn't do anything like that.
One of the individuals who introduced you mentioned the confession of error that you published in 2011. What was the reaction to that? By whom, assuming that there was one?
Yeah. So actually, let me tell you, this is to take Mary both these questions. Confessions of error is a really interesting thing. So here's what it is, and it goes all the way back to Taft when he was Solicitor General. You come into the Supreme Court and you say, Supreme Court, that case we won on behalf of the federal government, we should have lost it. So literally I did this. We'd win, or one of our U.S. attorneys, for example, would win a case, say in Chicago, in the Court of Appeals for the Seventh Circuit. We'd look at it and say, we should have lost that case. So we ask the Supreme Court to hear the case, petition for certiorari. You know, they get about 7,000 requests a year and they take 70. And we make it one of our requests to say, take this case and rule against us. We should have lost. It's a remarkable thing for an advocate. If you hire a lawyer and the lawyer looks at you and says, okay, yeah, I'm going to go to court and I'm going to say you should have lost this case, I mean, you would fire that person. But the idea is in the government, and this is what makes the job so great, your job is to do justice. It's to do justice, even if it means you lose the individual case. Now, with respect to Hirabayashi and Korematsu, those cases are long, long over. There wasn't a mechanism to, you know, get the Supreme Court to hear the Korematsu case. That is not going to happen. But what I was trying to do was hearken to those principles and those traditions. And, you know, the government is always concerned whenever, you know, there's something said. There were lawsuits that have been filed about Hirabayashi and Korematsu and other things, and damages and so on. So you get a lot of that and so on. So, you know, it wasn't, I'm not saying that it was easy, but I also, you know, John is very sweet and talking about courage and so on. The bottom line is, I had tenure at Georgetown. So, like, you know, what are they going to do? So, you know.
What are the limitations to the president's executive orders?
What are the limitations of the president's executive orders? So the president has limited this new one to 8 countries. So it's not around the globe. It's 6 countries that are overwhelmingly Muslim, between 90 to 99.9% of their population Muslim, and North Korea and Venezuela. The Venezuela thing applies to government officials, and you know that's something the president obviously has power to do, to exclude government officials from some foreign country. There's a specific authorization for that. So, you know, the Venezuela thing is really window dressing, but it is limited to those things. And then the president does say that he will individually provide waivers on a case-by-case basis in individual circumstances. So at the end of the day, you know, and this is what I think his advisors are saying, is this is just like the first executive order and the second one, except it's permanent now as opposed to temporary. And, you know, interestingly, he sent out his lawyers for the first and second ones and said their argument to the courts was, this is only temporary, it's only temporary, so don't rule on it because we just need some time. And now they've made it permanent. And so, you know, there's a little disconnect between the legal defense and what the policies are that are being enacted. There's a question all the way up there. I don't know if we have a microphone, but if not, maybe you can, if you can say it loudly, I'll repeat it for everyone.
So,
So the question is, would the administration use Korematsu to defend the travel ban? I sure hope not. It is notable that President Trump, in that December 7th speech, did invoke the FDR precedent as his defense. It's like, oh, what's the big deal? FDR did this. It's you really hope not. But at this point, very little surprises me. I mean, with stuff coming out of the administration. I mean, I never really thought I'd see a day in my life in which the President of the United States, when he loses a court case, goes and attacks the judge for being so-called or being political. Or his Attorney General says, I can't believe a little island in the Pacific could do this to the United States, which happens to be a state. So these are, deeply corrosive anti-American views.
This may be cliche, but I guess my question for you is, what advice would you have to the students and the law students here in particular, as far as what their goals and aspirations are to fight in similar ways that you are for these particular ideals and truths?
Well, the most amazing thing about the law degree is, once you got it and you pass the bar, you can do everything that I've been talking about. I mean, it's an amazing amount of power to be able to call in, to defend in court a policy of the United States government. It could be a big policy like travel ban. It could be an individual way a criminal defendant has been treated. That is a real privilege. And it doesn't matter to me what your day job is. You could be at a law firm, you could be in-house at a company, but you can do this work. And indeed, it is also actually very good from a career perspective to do this work. It gives you experience. I mean, Gitmo was my first case. Before that, I'd argued one criminal appeal when I was at the Justice Department, but that's it. And I'd argued like a traffic ticket or something. But it launched me into a whole different career path that I didn't really know that I was going to do. Particularly today, with fewer and fewer cases going to court, the pro bono stuff is really important. And so I do think you should do it because it's what is the right thing to do, but I also think you don't lose anything, and indeed you may gain something from a career perspective by doing it. And I do think it's important to do what speaks to you. I mean, I have someone in my office who really cares about parental rights issues, and it's not something I really thought about before, but he has a little side practice on pro bono representation of that. But unfortunately, there's a deep need, and particularly with legal services cuts, and public defenders cuts, a really deep need. And so there's a lot of stuff out there, and anyone can do it. Whether you're at a big firm or small firm, as long as you do your work, they'll be supportive.
Professor, I had read that Trump's initial orders were based upon the same countries that were mentioned by Obama in an earlier order he had done.
If that was true, how did the earlier order escape the nationality issue?
Yeah, because the earlier, this was like the weirdest argument for the Justice Department to make. The earlier order was the visa waiver program. And it just said that some countries you need a visa to come to the United States and other ones you don't. And it's certainly true that the 7 countries on the initial list were ones that President Obama said that you need a visa to come in. We're not going to waive a visa a requirement. That is not anything like discrimination on the basis of nationality and who gets to come here. That's just basically a question of, are we going to throw you into a visa process or not? It's not a way, do you need to go through the paperwork? But it's not a flat bar on this. So President Trump's view is you can't come in if you're one of these 6 national of these 6 countries. Obama's view is absolutely you can come in. You just got to apply for a visa. And obviously, if there's individual determinations that someone's a terrorist or something like that, that person will be precluded. And absolutely, 100%, I think that's right. I mean, I'm not saying that you can't go to a country and say, or to an individual and say, oh, we're not going to, inquire as to whether you're a terrorist or not. Absolutely. But we're also not going to be able to make the kind of gross nationality-based distinctions that just say, you entire country with 99% of your population being what it is, you're not allowed in at all. So it's the difference between a flat ban and a case-by-case approach. Obama took the case-by-case approach. That's entirely permissible under the immigration law, and Trump did not. And of course, Obama didn't have the same history in enacting this. He wasn't campaigning for a Muslim ban or saying the things he was saying about Islam. And indeed, the visa waiver program applies to all sorts of countries. It didn't just apply to 6 or 7 overwhelmingly Muslim countries. Up, and then I'll repeat it.
Professor, first of all, thank you very much for your comments. One of the themes that has run through your comments today is one of the lawyer, particularly the government lawyer, as an officer of the court. I mentioned a few different examples where lawyers displayed real candor in a way that we wouldn't expect necessarily. We didn't know about the obligations of lawyers. You also alluded to the fact that we may have seen some erosion of this role. So my question is, do you think that the erosion perhaps that we're seeing with the role of the lawyer, particularly government lawyer and officer of the court, is this a permanent erosion? Is this something we're going to continue to see, or do you think that we can turn this around?
Yeah, I think it's too early to tell yet what the Trump administration's view will be. It certainly does seem like the president does not tolerate any independence among his agencies. And if that continues, that will destroy the independence of the Solicitor General. Because you can't have a Solicitor General that does the White House's bidding and then claim to be independent. It's just not going to happen. And the result of that will be that the Solicitor General will lose its luster in the Supreme Court. I'm not at all saying that has happened, but I am saying if the president treats his Solicitor General the way he seems to treat his other cabinet officers, I mean, besides the IQ tests and that stuff, but that I think that we will see, a real erosion of the office. But, so far we don't know yet, we're just a few months in, and I sure hope that those lawyers will stand up. I will say the career lawyers, and that office is mostly career lawyers. It's, there's about 20 legal positions, 18 of which are career. It's just the Solicitor General and the Principal Deputy that are political. Those career lawyers are amazing. I mean, the deputy with the fewest number of Supreme Court arguments has like 85. They're brilliant. They have total integrity in their class acts, and they will stand up. And so, I do think as we get despondent about political interference over what were previously largely independent institutions, the career folks in the Solicitor General's office throughout the federal government are important. I do think, how a government treats the dissenters is very important. I think President Obama in general did a good job, but not a perfect one. When there were people who criticized him within the government and voiced dissent. There have been presidents who've been better at that, but I thought he was pretty good. But this president seems to me to be on the low end. There are now all these whistleblowers who are filing lawsuits and who've been fired from their jobs and demoted just for saying, this isn't the right way of doing something. In the pink.
So, for the Guantanamo Bay case, you basically were allowed to pick your plaintiff. Do you believe you would have had the same outcome if they would have just handed you a guy who possibly had blood on his hands?
Well, that's a great question. I mean, would it have mattered with a different plaintiff? I don't know that it would have now, in retrospect, but at the time, Justice O'Connor was on the court. So when we first filed the lawsuit in 2004, and she really cared about the facts. And I would say today, Justice Sotomayor is someone who also really cares about the facts. And so, if it were Bin Laden versus Rumsfeld, as opposed to Bin Laden's driver, I think that for Justice O'Connor, it might have made a difference. And one of the things that, made the case work was, and this goes back to your question about what can students do, we had law firms. When I first filed the lawsuit, no one wanted to help us. But by the time we got to the Supreme Court, and it was clear that this was a two-bit nobody driver, as opposed to like some, trusted confidant or something. We had 38 law firms helping us, and really actually by the end over 1,000 different lawyers and law students across the country on our side. A lot harder to get 1,000 lawyers and 38 big law firms on your side when it's Bin Laden. So in some ways it's like, I'm not saying that it's just the facts of a case that will drive the outcome, the way, I think it was Holmes who said hard cases make bad law or something like that. It's not just that, it's also that the inputs that the court got were different because we had all of these resources available to us, because this guy was not the worst of the worst, despite what, Rumsfeld called him at one point.
I'm struggling with this question a little bit, but I was wondering, since we have about to destroy the Middle East, establish military bases in over 100 countries, I think, I just wondered if the establishment of the New World Order is going to be about to be completed, and do you think that Russia and China will stand by and let that be done?
I'm sorry, the what will be completed? I'm sorry.
The establishment of the New World Order. Since we are about the bald eagle, since it spread its wings from to encompass the west and the east.
Okay.
Do you think that's going to be completed anytime
soon?
soon?
Unfortunately, I don't know anything about that stuff, so I'm not the best person to ask. I'm the law guy, not the foreign policy person.
We are afraid, in other words, to get into that subject. Okay, thank you.
Okay.
Time for one more question, so I will ask it. A law question. So Neal, you mentioned provisions, and you actually quoted a provision from the immigration laws, the anti-discrimination provision. As you know, there are other provisions that the government and others have cited that seem to give the president some kind of discretionary authority to prevent individuals or maybe groups of people from entering the country. And some observers have seen a conflict of some sort between these two provisions. And could you say just a few words about that provision and how you see the argument going?
Yeah, I mean, I do think that the immigration laws do give presidents, wide authority to exclude persons or classes of people based on new information. So, the problem here is that there is no new information, that Congress has looked at these very same countries and have said the thing to do is the visa waiver program, not flat bars, but visa waiver. And so if it's an emergency situation or something, absolutely presidents have the ability to enact things. But here, when it's on the basis of nothing new, but simply the same information that Congress had, I don't think the president gets any additional powers or latitude in that respect, at least not without an express law of Congress that says so. And here there isn't anything, and much to the contrary, there are specific prohibitions like the one that I just read to you that say that you can't discriminate on the basis of nationality. Okay.
So we're out of time, but please join me in thanking